It has been an intense year as Minnesota, Minneapolis got ready for the Derek Chauvin trial. Jury selection started on March 8th. We are up to 13 jurors, and as I understand it, Judge Cahill wants to get a couple more so that we have about 3 alternates. We're going to get into all of this as well as Friday's rulings with Earl Gray. He's defense attorney for defendant Thomas Lane. He's been on the show in the past, but we have not talked with him in several months, and I thought this was a good time to get into things with him. Earl, thanks so much for coming on today.
Well, thank you for having me.
All right, let's start with Friday's rulings on those motions. Judge Cahill says we're not going to change venues, we're not going to delay this trial, and we are going to include the May 2019 video with George Floyd in a similarly situated kind of altercation with police. Your thoughts on any of these?
Well, I did not think that he would move the trial to another venue since he had already started it here in Hennepin County. But the reason the motion was brought was because you have to protect the record if you lose, if Chauvin should happen to lose, it's an appealable issue. Just starting the trial there at all, back when we attempted to change venue. And now, after he denied that venue change, that motion, and said we were going to try it in Hennepin County, first you get the Chauvin plea deal put all over the press and news, and then during the trial, you get the city and family of George Floyd doing a press conference and settling the case for $27 million. Those two facts you have to put on the record to bring the motion to change venue, even if he's going to deny it. And of course, there was an outside chance that he might not deny it and might move it. He did not move the trial, but we have 2 excellent facts if Chauvin happens to lose the case to argue that the venue should have been changed a long time ago. And the argument that, well, if we move it some other place, everybody there knows about it too. I respectfully don't agree with that, because it's been my experience, if you go outside the Twin City area to a smaller community, even a place like Olmsted County or St. Louis County, not many folks up there follow the Twin Cities incidents as
even something, Earl, that got so much global coverage.
Well, it got global coverage, but the question is, did the Minnesotans outside the Twin City area know that much about it? And it was never really established that they did know a lot about it. The judge just assumed that. He obviously was right to a degree, because he's now, within 2 weeks, he selected a jury. The lawyers and the judge have selected a jury with just 1 or 2 more alternates to be picked Monday or Tuesday, and they have their jury. Of course, you never know about that, because there's a week between Monday and the Monday when the case starts, and you don't know what will happen to these jurors during that time. If some of them decide they can't sit on the jury, or some of them are confronted with some bias conduct by the public, you never know. So,
Earl, I want to ask you about that $27 million settlement 2 Fridays ago now. Yeah. It just seems very prejudicial. It's a civil case. I realize there are different rules going on, but it was unprecedented, and the timing of it seemed very suspect to a lot of us.
Well, I think anybody involved in the criminal law, in the criminal justice system, or in the media, who have experienced civil cases, criminal cases, and the timing of the procedures would say this is absolutely wrong. everybody that I've ever talked to about it believe that it's wrong. And it's wrong because you did not have to do a press conference in the middle of jury selection. Even though they settled it and all the papers are signed, they could just wait till after the trial. They did not do that, and I believe their claim that, well, the courts let us do it or approved it is fiction, not fact. I don't believe that. I don't believe for a second Judge Cahill or the chief judge said, yeah, go ahead and do it. So
we're talking with Earl Gray. He's attorney for Thomas Lane, one of the officers in the events of May 25th, 2020. Thomas Lane is scheduled to go on trial in August. Earl Gray, how does this trial and what's happened so far affect Thomas Lane's trial?
Well, what has happened so far, we've seen the jurors that have been called from this jury pool, and a lot of lawyers and media that have been involved in the criminal justice system are somewhat surprised, let's say, that the jury pool has so many people of color and minorities when the percentage in Minneapolis is a lot less than that. I'm not saying it wasn't at random. It's just an interesting coincidence. As far as Thomas Lane's case, how this Chauvin case is affecting it, well, the effect of the Thomas Lane case, the Chauvin case affecting the Thomas Lane case, if Chauvin is acquitted of all counts, obviously they've got to dismiss Thomas Lane's case because he's charged with aiding and abetting Chauvin and Chauvin committing these crimes. Well, Chauvin didn't commit these crimes. How could my client be convicted of aiding and abetting him? So it's a big deal for the other three defendants. If Chauvin wins, in my opinion at least, the other three win because there's no principle. The main actor in this was Chauvin. The other three are charged with aiding and abetting Chauvin, which means willfully participating, knowing that Chauvin is doing what he's doing and criminally and intentionally participating in it. And that's a pretty high ladder to climb, I think, for the state. But as far as affecting Lane now, we're watching this, attempting to help as much as we can Eric Nelson out, and because we benefit from it. Whether we agree with what Chauvin did or not, as far as criminal law goes, if he's acquitted, we should be able to walk. So,
and is that the case for all of the charges? Now that the third-degree murder charge was added in, Earl Gray,
yes.
Give me that answer on that. What if that is the only charge?
Well, what's interesting is that the original complaint did not charge my client or the other two guys with third-degree murder. They only charged Chauvin with the third-degree murder. Then Judge Cahill dismissed it, and the state won its appeal, which is now in the Supreme Court. And they've brought a motion to charge us now with the third-degree murder too. And it's an important issue because the more counts you have charged against your client, the less chance of winning the case. And that's their theory, that we'll throw the stuff at the wall and hopefully something sticks. So as far as third-degree murder, how my client could aid and abet a deranged mind is beyond my knowledge of the criminal law. I don't know where they're coming up with that.
And that's why it's so important for people to remember there are, with all of these charges, there are elements of a crime the prosecution would have to prove beyond a reasonable doubt. And there's a jury that has to only make that decision based on the evidence that's given in court. How important, or is it important, that May 2019 video for both Derek Chauvin as well as for your client?
Well, that video was initially ruled out by Judge Cahill, as you might remember. It was a 404B motion. He said, no, you can't do it. Then my client, who still framed the activity of George Floyd in the backseat of the squad car, and we were looking at it, and by golly, we kept seeing this white stuff coming out of Mr. Floyd's mouth. So we requested, along with Eric Nelson and Plunkett and Pauly, but I think it was Nelson and I that went out there. Maybe Plunkett was there too. In any event, we got an appointment with the BCA to look at the backseat of the squad car. And this was only about 4 weeks ago. And lo and behold, they still had the squad car. It had been sealed and was parked in the BCA garage. Well, we went and we went and looked at it. We had an investigator along. We took pictures of it. And not only did we find white remnants on the seat that we took pictures of, but we also found an almost full pill on the floor. That substance was determined to be methamphetamine. That substance was determined to have the DNA of George Floyd on it. That evidence that we can show that he was now eating, because the other evidence we had before that, all we had was a still photo of him with a pill in his mouth. We allege it was pill. They said it was bubble gum or something besides a pill. But now with the evidence that we have in the back seat, the Judge Cahill looked closer at it and did determine, well, it is important now because we have proof that George Floyd was eating pills in the backseat of that squad car as he was on the 2019 May incident, which is, I think it's markedly similar, not remarkably similar, the State v. Ness case, but the judge said that it was markedly similar, both cases, and our defense, one of our defenses is causation, and he determined that it's important for the causation factor because of his medical condition back then. He allowed in the pill eating in 2019, and he allowed in the interview of the, not the doctor, but the nurse, and she took his blood pressure, and it was extremely high. And she also talked to him, and we can get her diagnosis in the evidence because it's admissible under the medical hearsay exception. So,
Earl, real quickly, because we're kind of running up against the clock,
sure.
Really quickly, your thoughts on cameras in this court?
Well, I my first trial on cameras in the court was in 1993, a triple homicide in La Crosse, Wisconsin. And after the first day, and as I recall it, the jurors were even shown in that, and that was a triple homicide. In any event, my thoughts, after the first 10 minutes, the lawyers do not even realize they're there. In fact, at times, I've tried many cases after that in Wisconsin with the television cameras running, and my only problem with it was that I whisper sort of loud, and I kept being told by the people watching it that they can hear me whispering, so I have to cut that out. But besides that, cameras in the courtroom after the first hour or so do not interfere with a fair trial. In fact, in my opinion, it enhances a fair trial because the court personnel, the lawyers, everybody knows that there's a TV watching you and TV camera watching you, and it's going to be there forever. I still have the final argument of the triple homicide back in '93, that I watch once in a while for pointers because I won that case. But I think cameras in a courtroom, I can't imagine within the next 10, 15 years that almost all states will have it. The question is, will the federal court ever approve it? And I don't think I'll be around by the time they approve it.
Well, Earl Gray, we are happy you're around today to shed some light on what's happening for your client, Thomas Lane, in his case, as you watch. I know yes.
One other thing about the juries, you get these critics on TV criticizing Nelson, but the main thing they don't know, and they shouldn't be criticizing, selecting a jury is what that juror says, but more important is the body language and how you relate to them. And these folks on TV saying, oh, he shouldn't have taken that person, that's ridiculous. The lawyer is talking with the juror and getting the juror's body language and seeing if that juror is the type of jury he thinks can be on this jury. So it's what the juror answers, but it's also their body language. And I'd like to add that. Thank you.
Thank you for adding that. Earl Gray represents Thomas Lane. And I know you are watching this with a lot of different layers. We appreciate your time today, Earl.